All right, guys, buckle up, because today we're diving into a courtroom roller coaster featuring not one, not two, but 5 sovereign citizens who think laws are optional and judges are suggestions. In this intro, we set the stage for chaos, a rundown of the defendants, a quick reality check on their bizarre legal claims, and just when you think it's safe, boom, we hit you with a sponsor and wild data breach stats. The tension's low now, but you can already feel the fuse burning. These aren't your average court attendees. They've come ready to challenge the system, with zero understanding of how it works. It's smug overconfidence versus real-world law. And trust me, only one is going to survive.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here,
Okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
Our first sovereign citizen steps up, claiming he's not on probation, while literally being on probation. He doesn't know who his attorney is, doesn't recognize the court, and thinks showing up is optional. The judge, trying to hold it together, starts laying down facts like bricks. You can see the tension rising. It's confusion meets consequence. He's told a public defender will be assigned, but still argues in circles. When it becomes clear he's in over his head, the court assigns standby counsel to prevent a complete meltdown. It's like watching someone read a map upside down and still insist they know the way.
Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
Now buckle in, because the next sovereign citizen just rolled in swinging with confidence and zero legal knowledge. He boldly claims he's representing himself, and the judge's reaction? A raised brow and a warning. That means you're stuck with your own mistakes. What follows is a slow-motion train wreck of pseudo-legal jargon. He throws around phrases he clearly doesn't understand, thinking authority comes from volume, not law. The judge, patient but firm, exposes every flaw with calm precision. This isn't just a mismatch, it's legal chess versus checkers. You'll find yourself cringing and laughing as reality checks start bouncing back hard.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't have license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the office in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you denying the motion? Because you don't have.
So Mr. Hicks. You're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You got to follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public
information.
information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right. No, you don't have a right to either or.
Yes, I do. Of course I do.
Start from this moment, where sovereign delusion is in full bloom. The defendant invokes constitutional magic, Title 18 mumbo jumbo, and even throws around the idea of jurisdiction like he's casting spells. But the judge? Unbothered, unshaken, and completely in control. She dismantles every claim with legal precision, pointing out that Google isn't a law school. The defendant grows more defiant, confusing confidence with correctness. It's like he's reading from a conspiracy blog, while the judge responds from actual law books. The clash is brutal and undeniably entertaining. This is courtroom theater at its most absurd.
All right, I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SB 1442547, counts 1, 2, and 3 SP 144-27651 and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now what I don't appreciate is, you know, I thought about that comment that you made that last time, you know, basically you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm gonna dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, so bye.
Because now, the judge puts the hammer down. After letting the sovereign theories run their course, she interrupts with authority that demands silence. She's not here for YouTube law. She lays it out plainly. Take the plea, or we're going to trial. No special rules, no courtroom fantasy. You can feel the air change. Even the defendant starts backing off, unsure of his next move. It's like watching a coach stop practice and say, "All right, enough playing." This is the system reasserting control. The judge's tone doesn't rise, but its weight is unmistakable. Reality just got the final word.
Pay close attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
Around 14 years.